Hello, good morning, good morning. Hello, everybody. Hello, welcome. Good morning, good to see you. Hopefully, everyone is having a good morning. Hello, good morning. Hello, welcome. Little bonus live today for everyone. Good morning. We have a very interesting order out of Arizona. I thought I would share with everyone here. So, yes, well, good morning. Welcome in. I know it's a little early, isn't it? It's a little early, but sometimes I think I just know when it's better to do it in the morning. Oh, hello, Carolyn. Good to see you. Katrina, Regal, good to see you. Hello. Oh, thanks, Geneva. Yes, these are one of my favorite sets for sure. I've had a lot of fun with these. Good morning, John. Hello, old stogie. Dolores. Hello, old and slightly grumpy. Samesies. Oh my goodness. Charlie, Jackie, Duchess. Hello. Hi, Lisa. Well, welcome everyone. Thanks for joining me this morning. This was kind of a last minute. I thought I would go ahead and jump on here to kind of go through this fun Arizona order that just came out. Fun, I know, is a relative term, everybody. Daisy May, hello. Ray Day, Carolyn, good to see you. Lisa, hello, good morning. So we have several states, everyone, that have been filing these false elector cases or conspiracy cases, right? So this is the Arizona case that had an order come out. Michigan's got some filed, Wisconsin's got some filed, so they're making the rounds. Of course, we have Georgia, which is probably the biggest well-known one. The DC federal case also involves the fake electors as well, or the false electors. We have lots of questions going on. So we've got kind of the same cast of characters that have been charged or are co-conspirators in these different cases. It depends on how things have been charged. So Mr. Trump is the only one who's been charged in the DC case, but he has multiple other co-conspirators that are unindicted. So Mark Meadows, everybody, is one of the key characters here. For Meadows, yes. Oh my gosh. Good morning. So Mark Meadows at this moment, actually let me pull this picture up here. Mr. Meadows. Oh my gosh. All right. So this is Mark Meadows here. All right. And he played a pretty pivotal role in everything that was going on. So yeah, so he's been charged in all of these cases. In the Georgia case, he's been trying to have his case moved. It right now is in front of the U.S. Supreme Court with a writ of certiorari. It's not been accepted or denied yet. Fani Willis has yet to file her response. She did get an extension for that, so we're waiting on that. But he has tried. He's tried to pull his case in Georgia into the federal courts. Now he has been charged. He's one of them that have been charged in the Arizona case, and he is again trying to move his case to federal court. So arguing with the idea that it was within the purview of his job that he was doing what he did during everything that happened. He's attempting again to move his Arizona indictment to federal court. Now, the judge has come down in this case and has said, no, these were not official duties. Now, one of the interesting pieces that's been raised is if we have another court here saying that the shenanigans that were going on were not official duties, then this could impact whether or not Mr. Trump's actions were official duties as well. in the DC case. And of course, we know if they were not official duties, then he's not protected by the immunity case that just came down. So lots of interesting copy and paste Arizona. Yeah. Yeah, Fonnie's having a bit of a rough week, in my opinion. I hope she's doing okay. There's that odd hearing going on. I've not really covered it because I don't want to put a lot of press on it because I think it's awful. But hopefully her week will get better. But she will absolutely be keeping her eye on this. And this can be used again as a situation where they're saying, we've got a court holding, we've got a ruling out of another court. Now, whether or not they choose to follow it, that's a different story. But it is a pretty good opinion here where the judge is breaking down Mark Meadows' role and whether or not any of the things going on here were appropriate as official duties. So I wanted to take everybody through the decision. The election fraud case, yes. So this is the Arizona one. So I know it's hard to keep them straight, but this is a state case out of Arizona. We do have a few other cases in other states, but this is specifically Arizona, the false electors indictment. Multiple people were indicted, and this is specifically for Mark Meadows. Oh yeah, there's a lot going on. Yeah, there's a lot going on. She's got a lot on her plate. So with that, I will go ahead and here, this is just an overview paragraph explaining this is a removal notice. But what I want to spend time on here is the background, which will set up why we're here to begin with, and then go through the judge's reasoning because he has denied removal. So I will take you through that discussion. But I'll kind of fast forward here a little bit through some sections. Hello, Ria. Welcome. So here we go, everyone. I will go ahead and just dive on in. Hopefully we will not have too many issues. So if the trolls get out of hand, just pin me a comment and let me know. Hello, Murray. Welcome. All right, so here we go, everyone. This is the Arizona false electors case, and we are dealing with Mark Meadows' removal motion. Hello, coffee drinker. Good morning. So here's our background. So to just give you a little insight as to where we're at. On April 23rd of 2024, an Arizona grand jury indicted 18 individuals on 9 felony counts pertaining to an alleged attempt to illegally overturn the results of the 2020 presidential election conducted in Arizona. The state contends that following the election, the 18 charged individuals participated in an organized scheme to prevent the lawful transfer of the presidency. According to the state, the actions undertaken by the charged individuals pursuant to this scheme included the commission of various state law felonies, including 1 count of conspiracy, 1 count of fraudulent schemes and artifices, 1 count of fraudulent schemes and practices, and 6 counts of forgery. The individuals charged by the state include 11 individuals who acted as so-called fake electors, corresponding to the 11 allotted to Arizona in the Electoral College, as well as 7 individuals who allegedly orchestrated and supported the scheme behind the scenes. Among these behind-the-scenes indictees is Mark Meadows, who served as President Trump's chief of staff from 2020 to 2021. At all times relevant to this case, in particular, the state alleges Mr. Meadows worked with members of the Trump campaign to coordinate and implement the false Republican electors' votes in Arizona, and was involved in the many efforts to keep Trump in power despite his defeat at the polls. So I'll go ahead and stop here. That was a brief overview of the role he's played. Now, keep in mind when we've got schemes here, when we have conspiracy, this is basically, and for those that have been with me when I went through this Arizona indictment, the way that they charged it in Arizona is very, very similar to the RICO case in Georgia, but in Georgia they've got that RICO statute. In Arizona, instead of a RICO, they charged it as conspiracy, all right? That means 2 or more people are conspiring and taking a substantial step towards an illegal act. They don't have to complete the act, they just have to take steps in pursuit of that act, all right? So Let's skip ahead again. So that's the background, and we'll get into the judge's discussion here. All right, here's our discussion. The well-pleaded complaint rule typically precludes. So the well-pleaded complaint rule is a rule in Arizona basically stating that, they're going to, when in doubt, they're going to say that the complaint was done properly. Precludes removal of cases in which federal jurisdiction exists only by virtue of a federal defense. However, Congress has enacted a limited exception to the general rule. Under the federal officer removal statute, suits against federal officers may be removed despite the non-federal cast of the complaint. The federal question element is met if the defense depends on federal law. The federal officer removal statute is codified here, and then it's set out. This is the same statute Mr. Meadows has been using in all of his cases. So they go through a little bit more analysis of that federal statute set out here, but because he goes through a full analysis of why it's not appropriate, I will go ahead and skip a little bit here. In their briefing, both Mr. Meadows and the state urged the court to adjudicate this case according to a three-pronged test that would require Mr. Meadows to show, 1, he's a federal officer within the meaning of the statute, 2, that there exists a causal nexus between the charged conduct and Mr. Meadows' official duties, and 3, that Mr. Meadows possess a colorable federal defense. This three-pronged test originates in case law addressing the propriety of removals by private persons acting under federal officers, in contrast to removals by federal officers themselves. So again, we're just setting out what law he's going to be using in order to do his analysis here. So I'm skipping ahead a little bit, and he's going into and explaining whether or not this test is appropriate. Nevertheless, the court sees no issue with using the test urged by the parties here. Although the three-pronged test finds its genesis in cases involving removals by private entities, the parties have sufficiently modified the test to comport with the circumstances presented to the case at bar. So we're going to be using this particular test, and I will fast forward again through a lot of the legal arguments just regarding which standard of review we're using here. All right. So fast forwarding again just a little bit. The state presents two main arguments. First, the state contends that Mr. Meadows filed his notice of removal after the 30-day deadline contained in Section 1455B1, and that he has failed to show good cause that might permit the court to excuse the untimeliness. Now, that's really important. Second, the state argues that Mr. Meadows has failed to meet the second criterion of the substantive three-pronged test because the conduct alleged in the indictment does not pertain to Mr. Meadows' role as President Trump's former chief of staff. So that's the one that's really got some teeth, everybody, and could potentially affect the DC case. Thus, according to the state, there's no causal nexus between its prosecution of Mr. Meadows' federal authority, thereby precluding a determination that this case is for or relating to any act taken under color of office. So what the state is saying here is that everything Mr. Meadows did regarding trying to keep Mr. Trump in power that's involved in this indictment is outside of his official duties. All right, that's what they're saying here. The court addresses each in turn. So here's footnote 1, and it says the state also presents, without expanding upon, an argument that Mr. Meadows is not a federal officer within the meaning of Section 1442A1, and thus fails the first prong of the three-prong test. At various points throughout its response, the state notes that the 11th Circuit recently held, that's Florida, that Section 1442A1 applies only to current federal officers, not former officers. So that was a huge case that came out. I'm sorry, that's Florida and Georgia. All right, so they're citing the case where he tried to have his case in Georgia removed, and the 11th Circuit said no. Although the state expressly contemplates that the court here might align with the 11th Circuit and hold that Section 1442A1 is inapplicable to Mr. Meadows as a former federal officer, the state does not actually present an analysis whoops, of why the court ought to so fine. Accordingly, although the court does not deem the state to have waived its first prong argument, the court elects to resolve this case on the two issues that were substantially briefed, namely whether, wow, everybody, you don't want to miss one of your key points. Mr. Meadows had good cause for his untimeliness under Section 1455B1 and whether the charged conduct relates to acts under color of office pursuant to 1442A1. Dueling electors is not legal. Expats, actually. JFK did it in Hawaii. That's not correct. There was something similar to that done in Hawaii, as I pause for a moment to remind everybody that Hawaii had just become a state just about a year or 2 years prior, and there was some question because the governor of Hawaii didn't know exactly what was going on. So that is false, and if you do some research, you'll discover that. So here we go. Let's move over to the untimeliness argument here. Going to be more informed about this. Oh, go for it. Oh, good luck for you. Good luck. All right, so here's the untimeliness argument here, everyone. The parties do not dispute that Mr. Meadows filed his notice of removal 48 days after the arraignment in Arizona State Court, and that the filing is thus untimely by 18 days under Section 14 of 55B1. But Mr. Meadows argues he had good cause to file late and in effect asked the court to grant him leave nunc pro tunc for his late filing. So, despite the fact that he filed it late, Mr. Meadows offers 3 arguments to support the finding of good cause. Number 1, he delayed filing the notice in order to pursue an effort to convince the state it should not pursue the charges against him. And he delayed filing while awaiting the United States Supreme Court decision in the immunity case. So, he's saying he was waiting for the Supreme Court to decide presidential immunity, and so that's why he was late, which he asserts bears upon his immunity defense in this matter. And 3, the court should interpret the removal statute broadly in favor of removal. These arguments fail to persuade the court. Muted for disinformation. Thank you, Deborah. Yes, that's a trigger, everybody. That Nixon JFK election is a trigger for me, seeing as how Mr. Penguin is the one that decided to put it out there and led to all of this bologna sandwich business. While attempting to resolve a matter by mutual assent of the parties to avoid court involvement is both laudable and sensible, parties universally face limitation periods and deadlines in bringing actions. They do not simply forego meeting those congressional or court-imposed deadlines to pursue settlement and then beg the mercy of the court if the settlement fails to materialize, which is important. That is to say, it is well-trodden path familiar to all counsel to pursue dual tracks in representation, which is one of the first rules we learn, everyone. Timely filing an action, or in this case, a notice of removal to protect their client's interests while they simultaneously pursue settlement, which is very important. Alternatively, parties can and do seek tolling agreements, which was made famous in Mr. Trump's New York civil case involving the AG. Here, Mr. Meadows did neither. Despite one or both options being easily available, Mr. Meadows' first purported reason for failing to timely file his notice does not present good cause. Again, good cause is the legal standard that needs to be met. Mr. Meadows' second reason for missing the unambiguous deadline set forth in 1455B1 fares no better. He asserts he waited to file his notice of removal because he anticipated the Supreme Court's ruling in the immunity case, and it could bear on his immunity defense. And upon its issuance, he argues it does so bear. But again, there is no reason to miss the deadline to file his notice of removal. Perhaps the Supreme Court's holding in the Trump case does strengthen Mr. Meadows' claim, and perhaps it does not. That question will remain until it is taken up in the context of a possible motion to dismiss his case, filed in the proper forum. Ooh, ouch, that's a burn. But the ultimate success or failure of Mr. Meadows' federal defense need not have been determined at the time he filed his notice of removal. He merely needed to be aware of its existence as colorable, meaning it's an option. And he was aware of its existence. He, in fact, contemplated raising immunity before the opinion in Trump issued. And then we have footnote 3 here. In response to the court's direct question at the evidentiary hearing, counsel for Mr. Meadows acknowledged he was not arguing that, but for the issuance of the opinion in Trump, he would not have sought removal. But for is another legal standard we're using here. While Mr. Meadows might well want to delay filing a motion to dismiss until he's had an opportunity to evaluate the Supreme Court case for the potential impact on his argument of the immunity defense, the filing of that motion is even now still well into the future, and there was no need or reason to delay filing the notice itself. Watching from the UK. Well, hello. Mr. Meadows does not appear to argue that his late filing was the equivalent of a second notice of removal under 1455b2, nor could he, although section 1455b2 provides that a defendant may file a second notice of removal on grounds not existing at the time of the original notice. As the court notes above, the proffered federal defense of immunity was already extant from the commencement of the state criminal matter. Whoa, that's another burn here. The judge is saying, not only that, but you could have filed another one if the case had not come down the way you had wanted it. Yes, exactly, VC. While Mr. Meadows believes the immunity case may strengthen his existing defense, it does not bring new grounds into existence as required for a subsequent notice filing. The text of Section 1455b2 also supports the court's conclusion that the publication of the immunity case does not constitute good cause under Section 1455b1 if the court were to countenance Mr. Meadows' untimely filing of his notice of removal simply because he suspected that a subsequent opinion might strengthen his position, which is essentially what Mr. Meadows asked the court to do here. The court would impermissibly render the second notice provision of Section 1455b2 a nullity. The existence of a filing deadline in conjunction with an express statutory right to file a second notice of removal only on the grounds not existing at the time of the original notice indicates to the court that Mr. Meadows' voluntary delay in this case cannot constitute good cause under Section 1455. Oh, thank you so much, Navy Vet. Oh, excellent. Love that. A contrary conclusion would relegate the second notice provision of 1455b2 to the status of surplusage whenever a criminal defendant could plausibly claim that a pending case might bear upon his potential removal of the prosecution in federal court. I want to pause for a moment because I've got a question. I've got something I've been pondering myself regarding Mr. Meadows. So Mr. Meadows wants to get everything into federal court, of course, right? Because that's going to play better for him. But also, I'm wondering what exactly the relationship is between Mark Meadows and Clarence Thomas, right? I think we have some issues going on there. And I think, again, he is, even though he is well past a deadline, this is completely unacceptable behavior for any attorney to file this late. It would actually be embarrassing to file when you're so outside the lines of the deadline. But I'm wondering again if he's saying, well, I've got an inside source saying that even if I file it and they deny me, that I've got a source saying I can appeal it and it might get reversed. I keep thinking about that. Oh, thank you, Glenn. I keep thinking about that and wondering again if the reason why he keeps pushing this is because Thomas has made some kind of a signal to him, like in the concurrence to canon, that he will kind of help push it along. Seems like it might be something. Yes, it just seems like, again, why are you pushing I mean, I get it. You want to be in federal court, and that's important, but we are way, way past the deadline of when you should have done this. Like, why even take the chance that you're going to get scolded like this? Highly unethical. Well, quite right. Right. Thank you, Susan. Oh, I just picked up my mug. That's so funny. There we go. Finally, in his reply, Mr. Meadows urges that despite his missing the filing deadline by 18 days, which again, it's not like a day or two or even a couple hours late, the court should nonetheless heed the clear command from both Congress and the Supreme Court when the federal officers and their agents are seeking a federal forum. Courts are to interpret 1442 broadly in favor of removal. I don't know, it's suspicious, everybody. And the court follows that command. But the broad interpretation of Section 1442, Mr. Meadows notes, bears on evaluating the merits of the removal test. It does not mandate or even counsel courts to throw out the statute's deadline as set forth in Section 1455. In support of his argument, Mr. Meadows cites Durham. That case proves the court's point. The Ninth Circuit in Durham held that a 30-day filing deadline for federal officer removal does not begin to run until the defendant in the state court matter receives disclosure. Exactly, Kirby. I agree. Suspicious, everybody. It's suspicious. I'm definitely starting to wonder. I've got questions. Durham does nothing to diminish the operation or effect of the statute's 30-day deadline, and it does not, as Mr. Meadows suggests, teach that where federal officer removal is available in the name of broad interpretation, courts simply should deem any such case as constituting good cause. To do so would negate the 30-day limit altogether. As every removal notice by a bona fide federal officer would, upon filing, no matter its timing, constitute good cause for extension. The court concludes Mr. Meadows has not shown good cause for leave to untimely file his notice, but even if good cause had existed, he's failed to demonstrate the offenses charged in the state's prosecution relate to his former color of office as Chief of Staff to the President, as set forth immediately below. So he missed the deadline, and the court's not going to let him, not going to give him a pass on that. You know, the other thing, too, that just clicked in my mind, Ginny was texting Mark Meadows during January 6th, right? So, like, they already have kind of a special relationship. So it's really not that far of a leap here to say that he's got some kind of an inside track with the Supreme Court, right? Right? Yeah, Wendy, I'm not going to be covering the Diddy cases because they are just absolutely so atrocious that kind of language is just outside of the realm of what I'm willing to talk about, actually. But there are many other creators that will have plenty of wonderful, she is born, I agree, plenty of great posts about it. There's lots out there. Thomas has been a puppet. Yeah. It would be very interesting, Rohan, I agree. I did spend plenty of time in the essay world, and because of that, it's very difficult for me to go back, just because it is very traumatic. I think it's one thing to review cases and listen to cases, but when you've actually worked these kinds of cases, it just kind of does something to your soul. So unfortunately, I cannot go back. All right, let's talk about color of office. This is the big one here. All right. So we've got this statute that says you missed your deadline. We're not going to excuse it. But the color of office argument is really the one that we may see come up in D.C. And we may see Ms. Fonnie Willis also talking about it as well. All right, I think it's a fair question to ask about Mr. Combs because I do review tons and tons of cases, but those particular type of cases I just do not review. I've got several pretty severe essay cases involving Mr. Trump's world, and I still do not go through them because they are just too devastating. All right, color of office, everybody. Here we go. Oh, you never know, Geneva. All right, the parties dispute whether the conduct charged by the state relates to acts taken by Mr. Meadow under color of the Office of Chief of Staff. A jurisdictional dispute of this nature can take one of two forms: a facial attack or a factual attack. A facial attack by the plaintiff accepts the truth of removing defendant's factual assertions, but maintains that they are insufficient to establish federal jurisdiction. In contrast, a factual attack contests the validity of the defendant's factual assertions, undergirding the notice of removal. The standards governing resolution of those two different forms of opposition to removal under Section 1442A1 are similar to the standards governing an ordinary objection to subject matter jurisdiction brought under the Federal Rules of Civil Procedure, Rule 12b1. Quote, under that framework, where the moving party does not contest the removal notice's factual allegations, but but asserts that those allegations are facially insufficient to invoke federal jurisdiction, we accept the notice's factual allegations as true and draw all reasonable inferences in favor of the remover. Better go for more tea, everybody. When the plaintiff's motion to remand raises a factual challenge by contesting the truth of the remover's factual allegations, usually by introducing evidence outside the pleadings, however, the remover must support her jurisdictional allegations with competent proof under the same evidentiary standard that governs in the summary judgment context. Thus, in the factual dispute, the remover bears the burden of proving by a preponderance of the evidence that each of the requirements for subject matter jurisdiction has been met. All right, so this is a lot of legal language here and what the court is saying. So our courts are not here to decide issues of fact. They decide issues of law. But there are some situations, like a motion for summary judgment, where a judge will have to assess the facts and figure out whether or not there's enough in order to do a summary judgment. And in this case, the judge has to figure out, do we have enough facts here for removal? So they have to make an assessment. Anytime they're assessing facts, then we have to have some rules of evidence in play. And when we have rules of evidence in play, that means we also need to have some kind of burden of proof. All right, so that's how the system works. So here, they're saying we're going to use the same burden of proof as for summary judgment, which is a preponderance of the evidence. So we are not beyond a reasonable doubt that these facts show that removal is appropriate. We're not at that level, but we are more than we're more than clear and convincing. We're on preponderance of the evidence, which is the level that we have in a civil case. All right, so he's setting out here what burden of proof is needed and that we do have some evidentiary rules that are needed. So Mr. Meadows can't come in and just say, well, these are my facts, and so based off of my facts, you need to make your decision. The judge is saying, well, we do still have some rules regarding evidence here. All right, so that's what all of this legal jargon means. Okay, so just to clarify that for you. So the district court resolves such factual disputes from the bench, except when the dispute is intertwined with the merits of the case, which is another, term of art, I guess is what they would say, or one of our legal phrases that we use that takes us into a different set of rules if it gets into the merits of the case. At the evidentiary hearing, the court asked both parties as counsel whether this case presents a facial or factual dispute. The state answered that it has raised a factual dispute to Mr. Meadows' notice of removal, but Mr. Meadows disagreed and instead asserted that the disagreement here is facial in nature. The court agrees with the state on this point. So the court is saying, we believe this is a factual issue rather than on its face issue. All right, so that makes a difference. So in how they're going to go through the process of evaluating whether or not this is appropriate. In its indictment, the state alleges Mr. Meadows communicated with several Republican operatives. Oh, that's a trigger word. I don't think we've been using the term operatives, everybody, but I kind of like it. Let's go back. In its indictment, the state alleges that Mr. Meadows communicated with several Republican operatives, both inside and outside Arizona, in furtherance of the scheme to overturn the results of the 2020 election. Mr. Meadows incorporates these facts in his notice of removal. Indeed, rather than make any additional or alternative factual assertions, to support his invocation of federal jurisdiction, Mr. Meadows simply quotes the state's indictment verbatim. In particular, Mr. Meadows quotes the state's allegation that Mr. Meadows confided to a White House staff member that Trump had lost the election, but that Mr. Meadows nevertheless wanted to continue fighting the election results in order to pull this off for Trump. That Mr. Meadows received text from Kelly Ward, the chair of the Arizona Republican Party and one of the alleged fake electors, indicating that Ward felt that the Trump campaign's lawyers in Arizona were afraid of being blackballed by the left and were engaging in a total cop-out, that Rudy Giuliani, Ward, and others contacted Mr. Meadows regarding overtures they had made in Maricopa County Board of Supervisors, including one such call from President Trump to Clint Hickman, the chairman of the Board of Supervisors, and that the Secretary of Energy, President Trump's son, an Arizona congressional representative, and several others contacted Mr. Meadows with an aggressive strategy involving various Republican-controlled state legislatures, rejecting their state's votes and instead opting to send their own slate of electors to the Electoral College, to which Mr. Meadows responded, "I love it." Hello, Kaya. Welcome. Yeah, when did we step in a spy novel? You know, we never left. We've never left the spy novel. It's been, ever since Watergate, we've all been in a novel. In its response, and at the evidentiary hearing, the state introduced additional evidence relating to the prosecution that Mr. Meadows messaged an individual in Georgia, instructing him to explain to a second individual how the Republican elector's strategy was to unfold. That after receiving complaints from Ward that their attorneys were freezing her out, Mr. Meadows responded that he will push them. When he promptly did, that Mr. Schlapp, a lobbyist and chairman of the American Conservative Union, contacted Mr. Meadows requesting an allocation of campaign funding in Nevada, a leader on the ground, and 20 people to undertake the on-the-ground work. To which Mr. Meadows responded, quote, "Money has been allocated for Nevada. Tell me what you need. Just spoke to Rona, the chair of the Republican National Committee." That Mr. Meadows procured Governor Ducey's phone number so that Giuliani could reach him about the election results in Arizona. That Mr. Meadows wrote to a senior Trump campaign official that, quote, "We just need to have someone coordinating the electors for states." That Mr. Meadows, in response to a text from Senator Mike Lee regarding the alleged fake elector scheme, responded, quote, "I'm working on that as of yesterday," end quote. That Mr. Meadows, in response to a suggestion that Trump electors meet at state capitals to cast their votes, responded, quote, "We are." And that Mr. Meadows texted Congressman Jim Jordan, pausing, regarding the plan to have Vice President Pence embrace the fake electors. Quote, "I have pushed for this, not sure if it's going to happen," end quote. Schlappy Joe. Oh my goodness. Oh, VC. Oh my goodness gracious. Not only has Mr. Meadows not disputed any of the foregoing facts, which is kind of a thing, but he has necessarily relied upon them. Were it otherwise, Mr. Meadows' notice of removal would not contain any factual allegations supporting federal jurisdiction. Mr. Meadows asserts that the state's facts satisfy the jurisdictional requirement of Section 1442A1 because the facts alleged by the states consisted of, or at least relate to, acts taken under color of Mr. Meadows' federal office. Now, let's back up just a second here. We do have a footnote that was added mid-sentence, so I did go past it. We've got footnote number 4 here. Let's go through that. Mr. Meadows asserts that the state is impermissibly sandbagging him by introducing factual allegations outside the indictment in order to illuminate the nature of its prosecution. Notably, however, Mr. Meadows does not dispute these factual allegations, nor does he offer contradictory factual allegations. In any event, parties in the jurisdiction dispute such as this are permitted to introduce evidence outside the pleadings. Indeed, it would be odd for Section 1455b5 to require an evidentiary hearing, a hearing which Mr. Meadows expressly requested if contemplation of evidence outside the indictment constituted sandbagging. Oh, that's a smackdown right there. He's like, why'd you ask for the evidentiary hearing then? If all we had was what was in the indictment, why'd we even have a hearing then? Oh, I love it. All right, here we go. Sorry. Some of these judges just crack me up, everybody. All right, here we go. In other words, this is not a case in which opposing parties offer competing facts. Rather, it is a case which the parties offer competing characterizations of identical facts. Thus, for the limited purpose of this jurisdictional adjudication, the state and Mr. Meadows do not disagree as to what occurred, but instead disagree as to whether what occurred pertained to Mr. Meadows' official duties as chief of staff. Not supporting the alternative facts, that's right. I agree. I think every attorney died a little inside when we heard that, for sure. Kellyanne, yikes. We've all suffered. The dispute, therefore, turns upon the scope of the Chief of Staff's official authority and whether the charged conduct arguably falls within the scope of authority. In the Ninth Circuit, the scope and content of a public employee's job responsibilities is a question of fact. Citing case law here, in citing the Posey case, noting the existence of a circuit split on the issue of whether the scope of official duties presents a question of fact or law. I'm going to have footnote 5 here. In concluding that the scope of the content of a public employee's job responsibilities is a question of fact, Dahlia and related cases examined the issue in the context of Section 1983 First Amendment retaliation claims brought by public employees against their employers. Although that scenario is distinct from the factual situation here, the court finds the circumstances to be sufficiently analogous such that the holding in Dahlia is persuasive, particularly in light of the apparent dearth of positive law defining the role of a president's chief of staff. All right, back we go. Therefore, because the contours of the chief of staff's color of office presents a question of fact, the court concludes that the state's opposition to removal jurisdiction in this case constitutes a factual attack. All right, so the court's saying, look, dude, it's not facial, it's factual right here because we have to figure out the scope of your job. So that's factual. Accordingly, Mr. Meadows, each as a removing party bears the burden of proving by a preponderance of the evidence that each of the jurisdictional requirements have been met. However, the court's placement of the burden of proof is immaterial because Mr. Meadows would not prevail under any standard. Oh dear, we're going to have to highlight that one. That's another burn. Ouch, Judge. You don't want to see that in an order with your name on it. That is not what you want to see happen right there. Oh my goodness gracious. Oh dear. Yeah, exactly, Jennifer. Mr. Meadows frames the chief of staff's role as essentially the gatekeeper who controls access to the president, the filter for the president's time and attention, and the key official in charge of facilitating communication to and from the president. Although Mr. Meadows has adduced no evidence beyond his own say-so supporting his description of the chief of staff's official authority, the state has not offered a competing construction. Therefore, the court credits Mr. Meadows' assertion regarding the chief of staff's scope of office. However, this conclusion is unavailing to Mr. Meadows because his version of the chief of staff's color of office does not correspond to the facts of this case. In arguing that the charged conduct falls under the color of his former federal office, Mr. Meadows contends that the state has done no more than allege that he received and occasionally responded to messages from people who were trying to get ideas in front of President Trump or seek to inform Mr. Meadows about the strategy and status of various legal efforts by the president's campaign. That's interesting. Mr. Meadows asserts that the senders were seeking to get their message to the president through Mr. Meadows, to persuade the president's closest senior advisor, or simply to keep Mr. Meadows apprised of what was happening. And according to Mr. Meadows, fielding that sort of incoming from people who want the president's attention or to influence his decision-making is squarely within the chief of staff's responsibility. Thus, Mr. Meadows' core contention that the object of the state's jurisdictional attack is that his charged conduct, essentially facilitating communication to and from the president, related to the 2020 election, was within the scope of his official duties. Mr. Meadows has not so much removed the state's indictment as rewritten it. No, Mr. Meadows, no, don't rewrite it. Oh, my goodness. Oh my gosh. Contrary to Mr. Meadows' assertions, the state has not indicted Mr. Meadows for merely facilitating communication to and from the president or for simply staying abreast of campaign going-ons. Instead, the state has indicted Mr. Meadows for allegedly, oh my gosh, italics everybody, italics. Mr. Meadows for allegedly orchestrating and participating in an illegal electioneering scheme. Oh, goodness gracious. Few, if any, of the state's factual allegations even resemble the secretarial duties that Mr. Meadows maintains are the subject of the indictment. None of the factual allegations at issue here mention management of the president's time or facilitation of communication to and from the president, much less that any such time management or communication facilitation constitutes the charged conduct in this case. Similarly, contrary to Mr. Meadows' reframing of the indictment, he's not being prosecuted for receiving text messages intended to simply keep him apprised of what was happening with the Trump campaign. As already noted, the indictment has charged Mr. Meadows with coordinating and implementing the false Republican electors' votes in Arizona, not merely staying informed of the alleged scheme. To allow Mr. Meadows to recharacterize the state's indictment at the level of generality that he seeks to do would be to vitiate both the federal officer removal statute and the Supreme Court precedent, interpreting that statute as every criminal prosecution of a federal officer will in some vague sense involve that officer staying apprised of what's happening. That's true. You do have to stay apprised. Federal jurisdiction cannot turn upon amorphous generalities that will be present in all instances. Oh, I like this judge. This judge is cracking me up. Moreover, regardless of the extent to which any individual factual allegations might tenuously relate to Mr. Meadows' official duty to facilitate communication to and from the president, the court agrees with the 11th Circuit's conclusion that an accused removal theory must accord with a criminal charge brought against him. Therefore, it is the heart of the indictment that matters. And that's a direct quote, again, from the Georgia case. To allow Mr. Meadows to remove the action if any single allegation in the indictment related to his official duties would run contrary to both the removal statute and precedent. Thus, Mr. Meadows' legal contention that Supreme Court case law requires this court to credit Mr. Meadows' theories of the case rings hollow. The court rejects removal here, not because there's a problem with Mr. Meadows' theory of the case, but instead because there's a fundamental misalignment, oh my gosh, between Mr. Meadows' legal theory and the facts undergirding the state's prosecution. Footnote 6. Sorry. Oh my gosh, cracking me up. Sorry, tea break, everybody. It's pretty harsh, judge. Pretty harsh but fair. All right, number 6 here. To be clear, in apparent contrast to his argument before the 11th Circuit, Mr. Meadows does not contend that the Chief of Staff bears any responsibility for the supervision of state elections. The court therefore does not address the elections clause, the take care clause, or any of the other source of potential state election authority for federal officers. Oh no. He's saying, the judge is saying here, like, you didn't even plead your other options that could have potentially worked. That's so funny. He's like, you had some other things that could have worked, but you didn't plead them. In past cases, the Supreme Court has upheld removal where the federal officer's relationship to the plaintiff derives solely from their official duties. All right, let's see. Here, however, the state's charged conduct is unrelated to Mr. Meadows' official duties, although the court credits Mr. Meadows' theory that the Chief of Staff is responsible for acting as the president's gatekeeper. That conclusion does not create a causal nexus between Mr. Meadows' official authority and the charged conduct. Now, that line is very important. We may hear that line again, everybody. So we've got footnote here, 7. One minor contention in Mr. Meadows' reply is emblematic of this point. Mr. Meadows asserts that Special Counsel Jack Smith alleged in a separate cause that Mr. Meadows participated because, as Chief of Staff, he sometimes handled private and campaign-related logistics for the president. That representation, made by way of an artful alteration of special counsel's wording, is not accurate. Oh, nice. Calling him out. The special counsel did not allege that Mr. Meadows handled private or campaign-related affairs as Chief of Staff. Instead, the special counsel simply noted that the defendant, President Trump, his Chief of Staff, who sometimes handled private and campaign-related logistics for the defendant, and private attorneys, called the Secretary of State. He's citing the superseding indictment here, which, as you should. In other words, the special counsel merely alleged that Mr. Meadows, who happened to occupy the office of Chief of Staff, undertook certain private actions. The special counsel did not insinuate that all actions taken by Mr. Meadows during his tenure as Chief of Staff are ipso facto official actions under color of office. Oh, nice. Oh my gosh. All right. Only has an AA degree. Well, oh my goodness. All right, here we go. Therefore, because the court concludes the conduct charged in the state's prosecution does not relate to Mr. Meadows' color of former office, the court must remand this case to state court for want of subject matter jurisdiction. For the reasons set forth above, its order declining to assume jurisdiction over the state of Arizona's criminal prosecution of Mr. Meadows under 28 United States Code, Section 1442 and 1455, is further ordered discharging the notice of removal and remanding this matter to the Superior Court of Arizona for Maricopa County. It's further ordered directing the clerk of court to terminate this matter, dated the 16th day of September, signed by, who's this judge here? John J. Tucci, or Tukey, Tucky. I like this judge. He's cracking me up. What's ipso facto? So, it just means like without question, essentially. So what he's saying here is, during his tenure as Chief of Staff are ipso facto official actions under color of office. So just because they were actions done by the Chief of Staff, they are automatically part of his duties. So he's saying that's what ipso facto is meaning here. That just because you did an act when you were Chief of Staff doesn't mean it was because it was one of your official duties. But it's easier to say ipso facto. Does that make sense for everybody? By that very fact. Thank you, VC. It's tuckus. Tuckus? Tuchus. Is it a K sound or a ch sounds? I'm confused. Tell me, I'll believe you. Tell me which one. Oh my goodness. This Tucci. Tucci, really? I didn't even go down that road. I didn't even go down that road. All right, Tucci. Okay, thank you everybody. Tucci, Judge Tucci. I'm going to remember that now forever. Tucci, Tucky. I wasn't even... I had my vowel sounds off. Well, that's all right. That's all right. It's Yiddish, really. Okay, well, I'm loving it. I'm loving it. Excellent. Like Stanley Tucci. Oh, okay. I probably would have called him Tucky too. I know, it's awful. It's awful. I'm terrible. I'm a bad person. Oh, my goodness. My goodness. All right. I knew you were kidding. Festering sewer of corruption. I knew you were kidding. All right, everybody. All right. So let's get serious again. So there you go. There's the order from the courts. Oh, my goodness. English is hard, Ash. I agree. Definitely. Some words I'm like, yeah, no problem. But other ones I'm like, what did I just say? What word just came out of my mouth? I don't even know. Oh my gosh. All right. So here's our order. Came down here from the district court for the District of Arizona. He was denied. I thought the judge did a pretty good job. He's like, hey, let's use your definition of what the chief of staff does. But even with your definition, no, it's not. It's not within the purview of your job, the facts and your duties here. Not only that, but then even the easier question was you were outside of the date. You were 18 days late to file. And, without a good excuse, there you go. I'm from New York. No way. Nuh-uh. Oh my goodness. I had wondered some kind of metropolitan area. So there you have it, everybody. There's Mr. Meadows' plight. Again, this is Mr. Meadows here. He's still working on that appeal to the U.S. Supreme Court in the Georgia case. We've got Fani Willis doing her response soon. We should be seeing that. She did ask for an extension, so we've got a little bit more time. So there we go, everyone. Best handle on the internet. I agree. Can Mark claim incompetence? I'm not sure. I mean, no. Really, if you miss a deadline, that's like the number one malpractice ding that you get, missing deadlines. Our deadlines are so important to us. Like we fall asleep and jerk awake with like, oh my gosh, did we miss the deadline? Like that's for the rest of your life that happens. So these deadlines, you wouldn't miss a deadline like that. And the only way that you would not file is if you were not intending to file. That's really it. So for him to have missed this deadline, and he's saying, well, we were just waiting for the Supreme Court decision. You don't wait for anything. If you've got a deadline coming up, you file. If you've got 6 cases in front of the Supreme Court and they're going to be filed and they're going to be answered the day before whatever brief is due, you still file your brief. It doesn't matter. And everybody knows that. So here I think they're just kind of dinking around with this, like, I know a guy and he's really important kind of situation. So, is that almost repeating all the ones involved in the case? Well, yeah. I guess because he was chief of staff and the other ones had like a little bit less official title. Like Giuliani was, the attorney for the president, I guess. And Eastman, I don't know what this fellow was doing. He was like, I don't know what he was doing. An advisor, I guess. And this guy was in the Justice Department. So this guy's just a campaign advisor. I mean, again, this is Georgia, but it's the same cast of characters, really, just with the Arizona electors included. So that, would you reread the Jim Jordan part, please? That's so funny. All right, let's look. Okay, Jim Jordan for the chuckle here, and then we'll wrap it up. I know I highlighted it because I have to always pause whenever Jim Jordan comes in. Oh, my goodness gracious. All right, here we go. Hold on. Here we go. All right, so The judge is going through the things that Mr. Meadows allegedly did. So here we have this, that Mr. Meadows, in response to a suggestion that the Trump electors meet at the state capitals to cast their votes, responded, quote, "We are," and that Mr. Meadows texted Congressman Jim Jordan regarding the plan to have Vice President Pence embrace the false electors, quote, "I have pushed for this. Not sure if it's going to happen," end quote. And as we all remember, Jim Jordan was recommended to be indicted in Georgia. Oh, we love that. We love that. All right. So with that, everybody, I will go ahead and sign off for this morning. But thank you all for coming out and joining me for this kind of bonus live here. Oh, I love the zingers too, Amber. I live for them these days. We got to have those zingers. They give me life. So thank you all for coming and joining me and hanging out and learning something new here. I think it's really interesting to see how these arguments are being placed as regarding state versus federal. That's really what this whole situation is kind of all about. State election laws versus federal interference. So very interesting situation. You can find this online if you're interested. This is the case number here, and this is the order that was sent down. It's document number 21. So I will sign off for that. With that, take care, everybody. I will be putting this up on my Tube of You here within the next couple of hours. So have a great rest of your day, everyone. Take care.